डीम कन्वेंस। डीम कन्वेंस बड़ा ही महत्वपूर्ण विषय है, जमीन के मालिकाना हक। इस विषय पर बात करेंगे। महाराष्ट्र सोसाइटी वेलफेयर एसोसिएशन महासेवा और एमएनएस मीडिया न्यूज सर्विस के साथ मिलकर ये लगातार हम फ्री वेबिनार का सिलसिला जारी किए हुए हैं। हफ्ते में 3 दिन मिल रहे हैं, लेकिन जरूर मिल रहे हैं, ये सबसे बड़ी बात है। और आज का महत्वपूर्ण विषय अबाउट डीम कन्वेंस विच एफएक्यू, आपके जो सवाल जवाब होंगे पब्लिक जनता जनार्दन की, वो उसके साथ में हाजिर है मिस्टर प्रभु। तो इस विषय पर खुद आज हमारे जो डीम कन्वेंस की लड़ाई लड़े और सरकार से मनवा कर रहे डीम कन्वेंस मानव अभी हस्तांतरण, ऐसे मजबूत कानून जो जनता और प्लेट ऑनर्स के हित में है, ऐसे हमारे आज के कीनोट स्पीकर है हाउसिंग गुरु रमेश प्रभु जी का मैं स्वागत करता हूं। और तमाम जो पार्टिसिपेट जुड़े उनका भी मैं स्वागत करता हूँ। लाइव जो देख रहे हैं यूट्यूब पर, उन सभी का स्वागत है दोस्तों। और सबसे पहले मैं आपको बता दूं, हम वीडियो पर शुरुआत करेंगे तो पहली अपडेट है जीएसटी कलेक्शन दूसरे महीने में भी 1 लाख करोड़ रुपए पहुंचा। दिल्ली जीएसटी कलेक्शन की ये रिपोर्ट है। इसके बाद कारोबार बढ़ाने के लिए राहत का नया पैकेज। सरकार को आज पूरी कोशिश है कि कोविड संकट से बुरी तरह से प्रभावित सेक्टर की कंपनियां पूरी तौर से कारोबार बढ़ाने में ध्यान दें। इसलिए सरकार इस सेक्टर में काम करने के लिए वाली कंपनियों को कुछ राहत देने जा रही है। ये नया पैकेज जरूर सरकार अभी अनाउंस करेगी। तो ये एक रियल एस्टेट का सेंटीमेंट मजबूत रहेगा, ये बोल रहा है नाइट फ्रैंक एजेंसी है, बड़ी कंपनी है। नाइट फ्रैंक ने अपनी नवीनतम रिपोर्ट में कहा है कि 2021 में इंडिया का रियल एस्टेट सेक्टर सेंटीमेंट अच्छा रहेगा। नया साल रियल एस्टेट बाजार को आकार देगा और प्राइम आवासीय सेगमेंट सहित कमर्शियली औद्योगिक सेक्टर को पूंजी बाजार सेक्टर में निवेशकों पर रुझान बढ़ेगा। और एक आखिरी अपडेट से हम आज की इस शॉर्ट अपडेट खत्म करेंगे। ये तमाम शॉर्ट अपडेट है एमएनएस मीडिया न्यूज सर्विस की तरफ से, न्यूज एजेंसी। भारत की जीडीपी ग्रोथ 10% की रफ्तार से बढ़ सकती है। एस&पी ग्लोबल सेटिंग एजेंसी है, स्टैंडर्ड एंड यूजर्स एस&पी ने कहा है कि भारत की जीडीपी ग्रोथ अगले वित्त वर्ष में 10% की रफ्तार से बढ़ सकती है। ऐसा इसलिए संभव है कि क्योंकि भारत की इकोनॉमी में तेजी से के साथ रिकवरी नजर आ रही है। लोग अब मार्केट में आ रहे हैं और खरीदारी कर रहे हैं। तो ये एक एस&पी एजेंसी की एक अच्छी खबर के साथ में हम शॉर्ट अपडेट को समाप्त करते हैं और आज के इस महत्वपूर्ण डीम कन्वेंस के विषय पर डीम कन्वेंस की शुरुआत करते हैं आज के वेबिनार की दोस्तों। और डीम कन्वेंस मतलब मानव अभी हस्तांतरण मराठी में जिसको बोलते हैं, यानी कि आपकी हाउसिंग सोसाइटी यानी कि मालिकाना हक ले सकती है उस जमीन का। प्लेट ऑनर्स आपने हैं तो सही मोपा और रेरा के तहत, लेकिन जमीन का मालिकाना हक भी बड़ा महत्वपूर्ण होता है दोस्तों। जिस प्लाट पर बिल्डिंग है आपकी कोऑपरेटिव हाउसिंग सोसाइटी है, और यह कानून पर काफी लड़ाई काफी संघर्ष जंग लड़ी है महासेवा महाराष्ट्र सोसाइटी वेलफेयर एसोसिएशन और सीए रमेश प्रभु जी की पूरी टीम, हमारी पूरी टीम ने। और ये सरकार से उस वक्त पृथ्वीराज चौहान मुख्यमंत्री हो या दूसरी जो मुख्यमंत्री रहे, उनके कार्यकाल में काफी पेपर वर्क करस्पॉन्डेंट कर कर आंदोलन कर कर लोगों को साथ में लाकर प्लेट ऑनर्स तमाम और ये जो डीम कन्वेंस का कानून को हक में जनता के हक में लेकर आए सीए रमेश प्रभु जी महासेवा के चेयरमैन। तो आज इस विषय पर प्रकाश डालेंगे और आप तमाम लोगों के सवाल जवाब भी लेंगे कि क्या डीम कन्वेंस लोगों की जरूरत है, किस तरह से डीम कन्वेंस में आ जा सकते हैं और जमीन का मालिकाना हक कितना महत्वपूर्ण है ये भी ले सकते हैं। और डीम कन्वेंस के बारे में और भी आगे कौन वन विंडो हो सके उसके लिए भी हम महासेवा के तमाम जो पदाधिकारी हैं, प्रभु सर खुद हैं, वो सरकार को निवेदन दे रहे हैं और समय समय पर आंदोलन भी करते हैं। पिछले कुछ वर्षों पहले डोंबिवली में बड़ा प्रोटेस्ट किया था और तमाम डीम कन्वेंस को लेकर काफी सारी चीजें चल रही है। तमाम चीजों पे अपडेट देंगे आज के कीनोट स्पीकर सीए रमेश प्रभु जी। रमेश प्रभु जी किसी चीज के मोहताज नहीं है और उनका मैं बड़ी खूबसूरत लाइन के साथ में स्वागत करता हूँ। तारीफों के मोहताज नहीं होते अच्छे लोग, तारीफों के मोहताज नहीं होते अच्छे लोग, क्योंकि फूलों पर इत्र नहीं लगाया जाता, क्योंकि फूलों पर इत्र नहीं लगाया जाता। और ऐसे हमारे हाउसिंग के गुरु और हाउसिंग के जबरदस्त फूल या खुशबू देने वाले फूल हैं प्रभु साहब, तो उनका मैं स्वागत करता हूं। और प्रभु साहब, मैं आपका स्वागत करके आपका वेलकम करता हूँ, वार्म वेलकम, प्लीज वेलकम आए। और तमाम लोगों को आज के जिस महत्वपूर्ण विषय पर जो आपका आपका हार्ट है, बड़ा आपके दिल के नजदीक है, डीम कन्वेंस, आपने बहुत मेहनत की है पूरी टीम ने आपकी, तो इस विषय पर मैं आमंत्रित करता हूं आपको सादर, वार्म वेलकम। आपका मंच आपके हवाले, अब आगे का प्लीज वेलकम प्रभु साहब।
थैंक यू सुनील शर्मा जी, उदय शंकर जी, थैंक यू वेरी मच फॉर ज्वाइन। मैं भगवान से प्रार्थना करता हूँ आप और तंदुरुस्त हुए और जल्दी से जल्दी आप मुंबई में आइए और हमारा नवी मुंबई जो भी हाउसिंग सोसाइटी उनको भी सेवा देते रहिए। कमिंग टू द पॉइंट, आज का एजेंडा जो है वो है डीम्ड कन्वेंस। तो डीम्ड कन्वेंस क्यों आया, ये भी इम्पोर्टेंट चीज़ है समझना। सो मैं शुरुआत में एक 10-15 सवाल अपने आप को पूछूंगा और बेस्ड ऑन दैट मैं आपको प्रेजेंटेशन भी प्लेस करूंगा। तो लेट अस ट्राई टू अंडरस्टैंड व्हाई दिस वाज रिक्वायर्ड टू बी डन। सी, Maharashtra Ownership Flat Act came in the year 1963, though it started implementing in the year 1964 after making the rules. But from 1963 onwards till 2010, which means nearly about 50 years, so or 57 years. See, 1963, so that means 40 and another 10, 50, nearly 47 years, 47, 48 years. So there was no provision for deemed conveyance. But does it mean that there was no provision for a conveyance? The answer is no, there was a provision for conveyance. So what happened in the law when initially it was enacted? There are 18 sections in the Maharashtra Ownership Flat Act which casted certain obligations. It made obligatory on the part of the promoter, that is a builder, developer, to form the society as per section 10 and then give the conveyance under section 11. So it was never assumed that builders will not comply. It was under the pretext that they will comply. So if there are some litigants or some developers, if they don't do it, naturally the law emphasized that those people may go to the appropriate court and get the remedy, maybe civil court. So that was the idea, and that is why there was no what is called as a regulator, or there was no competent authority who could comply, or who can observe, who can facilitate compliance of the various obligations of the promoter. Now, what are the obligations of the promoter under Maharashtra Ownership Flat Act? Pehla obligation is he should make things clear, he should give the agreement, he should give the plan, he should disclose all the details. All this is given in section 3 and 4 of MOFA. Section 10 of MOFA says, yes, he has to form the society. Section 11 of MOFA says he has to give the time prescribed in the rules. The rule says the conveyance has to be given within 4 months of the formation of the society. So ये पूरी चीज कायदे में लिखा है. But as I said, there was no implementing agency, and therefore it was necessary for the government to hear the various grievances of the people. Now, after hearing the grievances of the people, the government decided that why not make certain amendment, because any law which comes, that always can be amended. And that is how there was an amendment in the year 2005 in the assembly, and in 2007 in the legislative council, and in the year 2008 naturally it was approved by the President of India to facilitate the deemed conveyance. So before going further, we also need to understand what is conveyance, what is deemed conveyance, what are the documents required for conveyance, what are the documents required for deemed conveyance, what is the procedure for conveyance, What is the procedure for deemed conveyance? What is the difference between a conveyance and the deemed conveyance? How they are different? What will be the implication of the stamp duty? And how the various, what are the documents required? How the process can be done? And what are the various government, you know, guidelines to this effect, circulars to this effect? And at the end, is there any judiciary order, whether it is of the High Court or the Supreme Court? So to tell you, the n number of circulars have been issued, n number of High Court orders are passed. There are some Supreme Court orders also. Today, the deemed conveyance has become a reality. That is the only thing I can tell you, that today the deemed conveyance is reality. So what I will do in next 30 minutes, I'll try to share with you the presentation. Because the presentation is going to be in English, I'll try to speak in Hindi so that people will be able to, make meaning out of it. And I'll straight away go to the presentation so that uh, one of you will be able to make up and then decide as to what we are talking about. So today my presentation is going to be conveys as well as deemed conveys. So I will be dealing with both the aspects. Now what do you mean by conveys? As the word conveys means transferring the title of the land and building in the name of the society. Whenever the land and building, the land and the building which is managed by the society, a registered housing society, in order to get the land and the building title transfer in the society is called conveyance. Now, why this required? What are the objects of the formation of the society? Why we need a conveyance? The most important is when you enter into an agreement with the land builder. Naturally, builder gives you an agreement for sale, saying that I will, construct the building. I will take so much money. I will give the portion of the flat in so and so year or by so and so time, and thereafter I will form the society and I will convey the land and building in the name of the society. That means in the agreement for sale itself, he says that he will convey the land and the building to a legal body which will be consisting of all the, so that that land and building can be managed well and monitored well. So in order to become a legal owner, unless until the documents are in favor of the society does not become the legal owner. An individual agreement for sale, there may be clauses mentioned, but to become a legal owner, you need to have the conveyance. So therefore, the society becomes a legal owner only after getting the conveyance. Second is to make entries in the government record. As we know that we have to make entries in the government record. The government, especially the revenue department, whether it is a city survey or Talati office, wherever we talk about where the land records are maintained, they will change the name of the owner in the record only when there is a registered conveyance deed in the beneficiary or one who wants to get the property card or the Satbara extract, 712 extract, or revenue record in their name. So in order to get the name incorporated in the revenue record, we also need to have the conveyance. And the third and most important reason is to have a free and marketable title. And marketable title. See, today when the builder constructs the building, naturally either he takes the conveyance of the land in his name, then makes the plan, constructs the building and sells. In most of the cases, what happens is the builder enters into a joint venture agreement that is called development agreement with the landowner, and therefore the land title continues to be in the name of the landowner. And he in the development agreement says that once the building is completed, OC is issued, and the people form a cooperating society, he will also facilitate conveyance of the land in the directly in the name of society, so that there is no further unnecessarily payment of stamp duty. Now what happens is, if a builder has taken a development right, the land remains in the name of the building landowner. Building is constructed by the builder. Flats are sold to the individual people in the name of agreement for sale, under the name of agreement for sale. And ultimately, society is registered having what is known as the registered society with the managing committee. So this way, if you look at the title of the land and building, it is partly held by various people. Landowner holds the land title, builder holds the construction title, flat owners hold the individual flats in their name, society holds the management right of the land and building, though they are not the owner. Because of the virtue of formation of society, they become common owner. So in order to become that particular land and building free and marketable, and so that society can deal with that property in the way they want, whether it is related to redevelopment or receiving the compensation for road cutting or handing over certain land to the government authority, whatever may be the reason. So to have a free and marketable title, the conveyance is done. Now let us come. It is a conveyance of land and building. It's not only the land, it also consists of the building. So when we talk about land, it is not that only the land below the building, the upper tenant land, the RG, common area, road, everything, whatever is available to the society, that will be conveyed, and then there is a building. Now challenging part here is, in the case of a layout, what happens is nowadays there are all multi-story buildings, and secondly, there are multiple buildings in one layout. So if there is a layout in which there are 4 or 5 buildings, and every building is formed as a separate society, the entrance is one, common road is one, RG is one. In such cases, there is a question arises: what land will be conveyed to each society? We understand building can be conveyed, each building is a separate standalone building, so the respective building can be conveyed to the respective society. But however, in order to convey the land, naturally, undivided are being verified. When I say undivided right, each society will have an entitlement based on the FSI consumed for the respective building. Proportionate thereafter will be transferred by taking the architect certificate. So architect will be in a position to explain as to how much is the total FSI available on that plot of land, which is a layout land, in which how much is the RG, how much is the road area, how much is the open area, other common areas, and then how this land building based on the FSI consumed building, how much building land entitlement can be assigned to each of the building. And this way, based on the FSI consumed, proportionate entitlement certificates are granted architect. Based on that, each society then will be able to get the conveyance of respective land and then the building. There may be undivided share because the property may not be able to divide. Reason being, there are FSI imbalance possible. The subdivision is not possible because there are so many common areas, common gardens, and common road. Now the question arises: what are the various ways of getting the conveyance? No doubt we have decided and we have understood what is conveyance. We also decided that as a society we need to get the conveyance of land and building in the name of society. In order to do that, the first and foremost thing that a society should do is to approach the builder. Because ultimately it is the builder who is supposed to convey us the land and building. He is the one who has entered into agreement for sale. He is the one under the law, under section 11 of the MOFA, Maharashtra Ownership Flat Act, he has to convey. So therefore it is easier that we approach the builder whom we have paid some rupees collectively. Secondly, if the builder does not give, then the second methodology is we can go to the various courts. Now, which are the courts where we can go? We can discuss it later. But basically, there are 3 courts which we will discuss. And the third is that in case the society does not want to go to court because this is a lengthy process, then an amendment in the Maharashtra Ownership Flat Act will be done, wherein it says if the builder or the landowner do not convey the land within 4 months from the formation of the society or as per the statutory period, then the law itself has provided that it will be deemed to have been conveyed. That means, just to give you an example, all the societies who are registered prior to 4 months from today have received the deemed conveyance. So therefore, a lot of people ask me a question, sir, under the deemed conveyance, am I able to go and do the redevelopment? Sir, under the deemed conveyance, did I get the title? The answer is, the law is provided that it has been deemed to have been conveyed. When I say deemed means, it is more of a legal fiction. So therefore, a certain procedure need to be followed to get actual conveyance. So we will discuss that little later, how this process happens. But basically, when we say that when we are going to the builder, or when we are going to the court, or when we are going to for a deemed conveyance, is the procedure different? Honestly, all the three procedure remains same. What is the procedure? Procedure is that you prepare a conveyance deed, let the builder sign, landowner sign on their behalf, society sign on their behalf of purchaser, and pay the appropriate stamp duty and get it registered. This is as simple as that. Now, in case builder does not come forward, landowner does not cooperate, naturally the court will hear both the parties and they will appoint a registrar who will execute the conveyance deed on behalf of the builder and the landowner. Now, under the deemed conveyance, one need not go to the court. Whatever the passed, same thing has been incorporated in the amendment done in the Maharashtra Ownership Flat Act to provide the deemed conveyance. So there, the directly registrar is appointed by the honorable, instead of appointed by the court, it is the government through a government notification and amendment in the MCS, amendment in the Maharashtra Ownership Flat Act. The district deputy registrar himself is appointed as a competent authority to execute the conveyance. In the court cases, after hearing the party, the executive officer who will execute the conveyance deed on behalf of the builder and landowner. Here is the situation under the deemed conveyance. After 4 months, the DDR himself is considered as officer who will execute the conveyance deed on behalf of delinquent promoter. So this is how the entire process of conveyance to the builder, through the court or the deemed conveyance is possible. Now I will take you through the, if at all a builder is cooperating, what are the steps involved in getting the conveyance. The first step involved is, as I said, we approach the builder. Whenever the builder has to give the conveyance, naturally he will look at least 3 or 4 important documents. One is the document which is related to the society. What is the document related to the society? Naturally, the registration certificate, and of course the resolution passed in the general body, resolution passed in the managing committee to obtain the conveyance. This could be the document related to the society. Then the document related to the land, because conveyance of the land, therefore anything related to the land, whether it is a NA order, whether it is a 7 extract, whether it is a property card, anything related to the land. The next is, we are also going to convey the building. So naturally the building, when I say building, that is a certificate or a completion certificate, occupation certificate. And the last document is, because ultimately it is a member who has formed the society, so the documents executed with the member by the builder, that is agreement for sale. Because in the agreement for sale, it has been mentioned that conveyance will be given. So therefore agreement for sale is required. When we talk about agreement for sale, naturally that will be stamp duty and registration. So this is all the documents that also need to be collected and handed over to the builder, so that builder will be able to convey the land. Now many people are under the wrong impression, sir, when we go for a deemed conveyance, the registrar is asking all these documents. See, as I said, when we are going for a deemed conveyance, registrar steps into the shoes of the builder for the purpose of granting the conveyance. If the builder does not have the document, all the documents will be collected from you. Same way, registrar is not having any documents of yours. No doubt the government has appointed him as the competent authority, but he has to collect all the documents from the aggrieved party, that means from the society. So therefore, all these documents need to be submitted to the registrar for getting the deemed conveyance in case builder does not cooperate. Thereafter, the society prepares a deemed conveyance deed. Once the builder agrees that I will sign, promoter says I will sign, then you have to prepare a deemed conveyance deed. Then get the deemed conveyance deed, conveyance deed executed by the builder and the landowner. Then you have to pay the appropriate stamp duty on the conveyance deed, because ultimately conveyance deed is going to transfer the land title and the building title in favor of the society. So whatever is the applicable stamp duty through the adjudicating process, then we have to register the conveyance deed with the sub-registrar, the way we register the agreement, then obtain the index 2 and also obtain the conveyance deed. Then we have to apply to the city survey office and get the property card changed in the name of society. When you look at all this process, builder signing the documents, rest all the procedure is required even when we are going with the builder. That means collecting the document, paying the stamp duty, getting it adjudicated, getting it registered, then approaching the city survey office. So these are the various departments which one has to attend even when the builder is cooperating. Now if the builder is not cooperating, as I said, we could go before the various judicial mechanism. What are the various judicial recourse available to us? The first thing, MOFA, the conveyance has to be given by the builder, and he has to give within 4 months from the declaration of society. And if he is not going ahead and giving the conveyance, we can naturally approach the civil court under the Specific Relief Act 1963 and get the conveyance order in our favor. This is the first thing that we can do. The second that we can do is we can go to the consumer court, and under the Consumer Protection Act 2019 now, earlier it was 1986, we can ask the consumer court to grant us the conveyance, because not giving the conveyance is a deficiency in service. Flat purchaser is considered as a consumer. The next is under section 13 of MOFA, Maharashtra Ownership Flat Act. Any obligation which the builder is supposed to do, and if he is not doing, it will be treated as a criminal offense, and therefore we can go to the magistrate court. We can go to the magistrate court and get the builder arrested, and then because the builder may be arrested, he may be blacklisted. Possibly the builder, by fearing, he may start the process of conveyance. No doubt criminal court will not give you directly conveyance, unlike civil court and consumer court. So looking at the various stages of litigation, and as a society is not in a position to do all this litigation, government in the year 2008 amended and rules were made, wherein as I said, where the societies are not given within 4 months, it is deemed to have been conveyed, so that we don't have to go to the court and get the order for conveyance. So that has been amended. However, in order to execute the conveyance deed, because builder and landowner are not going to cooperate, government appointed district deputy registrar as a competent authority. So district deputy registrar is appointed as a competent authority, and accordingly rules were made, and these rules were published in the year 2010. Since 2010 to 2020, 6,000 to 7,000 conveyance across Maharashtra has been done, out of which nearly 6,000 conveyance only must be from Mumbai and another 1,000 from Pune, Nasik and Nagpur. Now the question is, as I said, Maharashtra ownership flat was amended on 25th February 2018, 8, and 2010 rules were made, and district deputy registrar is appointed as a quasi judicial authority. Now, as I was saying, that deemed conveyance is nothing but it is as good as conveyed. Every society who has completed more than 4 months are deemed to have received the conveyance. So there is no problem. Now it is treated as a conveyed, so land is conveyed. It is a legal fiction which is created so that if the builder does not give the conveyance, landowner does not give the conveyance, you have taken the land, you are in the position of the land, you are managing society. Somehow the ownership has to be conveyed today or tomorrow and within the statutory frame, and therefore it has been said that it is considered as a legal fiction because it is an amendment which has been carried out in the law. Now, next comes is, if at all within 4 months it is doomed to have been conveyed, then what is that we are doing by going to the DDR, Competent Authority? By going to the DDR, what we try to do is we are simply trying to get the conveyance deed actually implemented through the DDR, because DDR will step into the shoes of the builder and the landowner, and he will prepare the conveyance deed, he will execute on their behalf, and so that the actual conveyance takes place. So as I said, just by declaring that you have received the conveyance by making an amendment in the law, you don't actually receive the conveyance, but the actual conveyance you can obtain by going through the registrar only. So therefore registrar will step into the shoes of the builder and hand over the conveyance. Now next question, what are the documents required for obtaining the either a conveyance or a deemed conveyance? So naturally, as I explained, whether you are going through the builder or otherwise, you need all these documents which I discussed. However, when you are going for a deemed conveyance, you need to make an application to the registrar online with all the documents that I am going to describe now, and then you have to pay 2,000 rupees court fee. Now, certified copy of the document, that means 7 extract or your property card. Certified copy of the building means commencement certificate or the building completion certificate along with the plan. Flat documents, stamp duty registration paid, and society registration certificate. Another document means if you have sent a notice to the builder, maybe a copy of the notice, area entitlement certificate from your architect who is able to go through the plan and tell you how much is the land you can claim under the deemed conveyance. City survey, in case the document contains some other number and the property card that you have also some other number, we need to show to the authority how the land is correlated, documents are correlated. Then of course we have to carry out the search and obtain the search report from the advocate. So this is what is required. Based on all these documents, we will be able to apply for the deemed conveyance. Many people ask me, sir, okay, you have given us the various methodology for conveyance, why we should take all these efforts? Because now you are saying that once the society is registered, land is there, and naturally it is deemed to have been conveyed, nobody can take away our right, then why should we do all these procedures? What is the advantage of a conveyance or a deemed conveyance? The first and foremost advantage is you become a ownership right, so the title becomes free and marketable. Otherwise it won't be a free and marketable. Secondly, all the commercial benefits will arise. What is the commercial benefit? Whether it is an increased FSI, whether it is TDR loading, whether it is a loading of the what is known as hoarding or telecommunication tower, whatever the commercial benefit, it will all come to the society if you have a conveyance. We have seen that the property which has a conveyance gets a loan quickly, so there is an appreciation of at least 500 to 1,000 rupees per in cities like Mumbai. Loans can be raised by mortgage. If you want to do the repairing loan, you can take, and even for the self redevelopment, we can take the loan. Balance FSI will be available with the society. TDR can be made, and permission for redevelopment is possible. All this is there once you have a title in your name. And when you say title, that means you should become the owner. And you can become the owner either by way of conveyance or through the process of deed. No doubt we can send the builders to the jail, but by sending the builders to the jail does not serve the purpose. At the end of the day, our title should be in our name. No, if the building collapses, what will happen? Suppose I don't have a conveyance, and just because I don't have a conveyance, what will happen? Will I be able to reconstruct the building? Will I be able to rebuild the building? Will I get the compensation from the government? The answer is, if you do not have the conveyance and the building collapses, unless until you get the conveyance in your name, you will not be able to reconstruct. Now, documents required, I have in detail discussed earlier, but at the presentation, let me just give you. Society registration certificate is always with the society. Stamp duty registration proof is available with the individual. Agreement for sale either with the individual or with the builder, or you can take it from the government department. Commencement certificate, municipality authority. Because many people tell me, why I am saying all this. Many people tell me, sir, going for a deemed conveyance requires lot of document. From where I want to obtain? All these documents we will be able to obtain by filing a RTI, right to information. So through the right to information, all this process is possible. 712 extract is with the form number 6 with the revenue office. Search report from the advocate, index 2 at the sub-register of insurance. Property card with the city survey office or the Talati office or Tahsildar. Any order from the collector of the district. If you have a development agreement or it is a registered document, we can collect from the. Suppose some of the documents are not available, you are not to worry. With the maximum documents available of the land and the building, one can go for deemed conveyance. Now, many times the society says our builder has sold the land to someone else. Instead of us, they are given to someone else. So therefore, the law says the promoter includes his assignees. If you see the third row, last row, includes his assignee. That means if the builder and the promoter has transferred the land title to somebody else, and that third person whom you have transferred also is included as a promoter, so therefore the DDR will be able to get you the conveyance even from the third person. Now, what is this amendment in the Maharashtra Ownership Flat Act? It provides judicial authority, who is a district deputy registrar, who will hear the parties. He will pass the order as to how much area we are entitled for a conveyance, and then he will also sign on behalf of the landowner and builder, and that is how he will convey the land and building. We don't have to run pillar to post. Even signing the execution of the conveyance deed also will be done by. Now, in the DDR, that is a common authority, there will be appearance and non-appearance. That means once you file the application with all the documents, the DDR will issue a notice to the other. So based on that, other side may appear or may not appear. If they don't appear, it will be non-appearance, and accordingly ex parte order will be passed. If there are certain documents where the other party needs an inspection, we need to give. Parties will have to file the relevant say, further says, rejoinder, all that can be filed like a court proceedings. And if the receipt of the reply from the opponents, the applicant to prove his contents and deal with the opponent's reply, whatever the reply opponent gives. So we can file a rejoinder countering each of the claim made by the others. Opponent may file the return, say the most important is there is no cross examination like a court, and we can always submit everything in writing. There will be oral hearing, and last important thing is that Within 6 months after making such inquiry, verifying the authenticity of the document and giving sufficient hearing as per the law of natural justice to the party, the DDR passes the order. So this is all about passing the order. The DDR passes the order, and then he prepares the conveyance deed, that is called unilateral conveyance deed. And once he prepares the conveyance deed, then of course, as I said, we will pay the stamp duty what is applicable, we will get it registered, and then the registrar will register the conveyance deed. Thing I can tell you, once the conveyance deed is registered, and then you can change the name in the property card, and that is how you will become the owner of the land. This is some photographs with Prithviraj Chauhan, who was the chief minister earlier, and the deemed conveyance I was discussing with. This is of course Sahkar Mantri Harshodhan, and my book deemed conveyance was released. And then of course this is a deed, conveyance deed, executed under the deemed conveyance process. If you are able to read it, Mr. Gorpade, the competent authority having a power under section 5A of MOFA. That means where the did not sign, that is the sunshine builder did not sign, the DDR has signed. If you see the last page, the common seal on behalf of the builder, where the builder has to sign because he is not cooperating. The district deputy registrar has signed, and with his seal, he has signed and registered the conveyance deed. On the buyer side, there are various other parties. Like buyer side, it is a society where chairman, secretary, treasurer have signed. Now, only question arises: conveyance, though I discussed it so nicely and briefly, but honestly, there are various provisions of law which are applicable, and there are many departments. Therefore, it is advisable for the purpose of conveyance, you approach the professionals and take their help, so that if something goes, the professionals will be able to guide. Second thing, what happens when you go for a deemed conveyance immersion, the builder will hire a very good advocate and he will mislead the competent authority, and ultimately you will not be able to know how to counter that advocate of the builder, and therefore you may have to, sometime lose the opportunity of getting the conveyance or the deemed conveyance. Therefore, I advise you that you hire a good professional who has an experience of doing all this and provide you the conveyance. So the conveyance is getting affected with the Registration Act, Bombay Stamp Act. Now it has become Maharashtra Stamp Act, Maharashtra Cooperative Society Law, Income Tax Law, Maharashtra Ownership Flat Act, ULC provisions, criminal procedure, civil procedure, planning authorities, land revenue code. Similarly, there are survey office, collector office, sub-registrar office, assessment department, collector office, revenue department. If there is a SIDCO, then SIDCO, and all this. So this is where Balasaheb Taurat, who was the revenue minister at that time, somewhere in 2011-12, we had interacted with him to get certain circular issued, wherein chain of documents, where we were required to pay the stamp duty, now you don't require to pay the stamp duty on the chain of document. The latest document, if the stamp duty is paid, is enough. Secondly, if there are some unsold flats, you don't have to pay the stamp duty. Third and most important, the common area and the land and the garden or the built-up area of the clubhouse, all these you don't have to pay the stamp duty. So all these circulars, by interacting with the then revenue minister, and even today he is a revenue minister, Balasaheb Thorat, we could get those things. And in fact, I am very happy to say that in the process of deemed conveyance and amendment in the Maharashtra Ownership Flat Act, I had an opportunity even to visit Rashtrapati Bhavan and become her guest. And these are some of my books which I had given to Rashtrapati at that time. This is my entire family, where you can see, and I had an opportunity to be for 3 days continuously at Rashtrapati Bhavan, and that was a great initiative. And this is Sachin Iyer, who is the housing minister at that time. He was a housing minister. My book in Marathi, Deemed Conveyance, was released. Now, there are court orders. I am not going in detail, but I can give you some of the hint as to what the courts have said. The courts have categorically said that if there is no OC or a completion certificate, deemed conveyance can be done. This is the first law. So therefore, don't have the deemed OC also, you will be able to get the deemed conveyance. Second is, if the matter is pending in the consumer court, still you can go ahead and file the application for the deemed conveyance, and if the deemed conveyance is granted, then naturally the application before the competent authority, that is a consumer court, becomes infectious. Next is, deemed conveyance is possible even if there is a balance FSI. Many people are under the impression that if there is a balance FSI, deemed conveyance is not possible. That is also possible. Now, dispute related to open space, or if there is any dispute related to the land also, still the deemed conveyance is possible. So all these are some of the judgments of the Honorable High Court. I am not going in detail. So with this, as far as I have tried to explain you as to how the conveyance has been made easier by the Honorable High Courts and the Supreme Courts, and also by the government. So thank you very much. Now
Yes,
the floor is open for question answer.
yes sir, thank you very much. मैंने नंबर भी चैट बॉक्स में शेयर किया, आप टीम कन्वेंस से रिलेटेड कुछ भी आपको सलाह या कुछ भी कंसल्टिंग करनी है, पूरी टीम हाजिर है महासेवा की, आप अपॉइंटमेंट ले सकते हैं। नंबर किया मैंने ऑफिस का, और मेल आईडी भी प्रभु सर की। सर सवाल मैं पढ़ता हूँ चैट बॉक्स में जो सवाल है। मिस्टर हेमंत का सवाल है, conveyance are a is affected to a housing society, is it a must date the society necessaries now need the undertake the change of ownership at the talati office 7/12? हेमंत का सवाल।
सी या हेमंत जी, आप सवाल अनम्यूट करके पूछ सकते हैं, बट
यस,
मैं जो समझा आपका सवाल का कि व्हेन ए कन्वेंस और डीम कन्वेंस अफेक्टेड टू ए हाउसिंग सोसाइटी, सो सी जैसा मैंने बताया, यदि लैंड का ओनरशिप आपको चाहिए, आप उसका मालिक बनना चाहते हो, आप जो उस जमीन के ऊपर जो भी एफएसआई टीडीआर है वो यूज करना चाहते हो, या आप जब भी रीडेवलपमेंट करना चाहते हो, आपके नाम से जब तक कन्वेंस नहीं होता है तो आप कुछ नहीं कर सकते हो। यदि कन्वेंस आपके पास नहीं है, फिर आप सिर्फ वो बिल्टअप एरिया का मालिक बनोगे। जिस दिन बिल्डिंग गिर गया, उसके बाद यदि बिल्डिंग बनाना है तो आपको फिर बिल्डर को अप्रोच करना पड़ेगा, लैंड ओनर को अप्रोच करना पड़ेगा, उनके सहमति के थ्रू ही आप कर सकते हो। सो देयरफॉर इट इज वेरी इंपॉर्टेंट फॉर यू टू बिकम द ओनर ऑफ द लैंड। जब तक आपका कन्वेंस नहीं होता है, तब तक रेवेन्यू डिपार्टमेंट, जैसा मैंने बोला, प्रॉपर्टी कार्ड डिपार्टमेंट या सिटी सर्वे ऑफिस या तलाटी या 7/12 आपके नाम पर नहीं होगा। तो ये दो कारण की वजह से आपको कन्वेंस करके लेना बहुत जरूरी है। यस हेमंत
Sir,
जी।
my question is that having done the conveyance, now does the society necessarily have to go to the Talati office and get that Satbara mutation done? Or it is assumed by default that
Yes.
the land ownership is now transferred in the name of the society?
Okay. Say, Hemant, let me
Yes.
just explain you. The title gets transferred only by way of conveyance deed. So
Correct.
when the documents are registered with the sub-registrar's office and both the parties have executed and registered, pay the stamp duty, the title gets transferred. Now, what happens is revenue department keeps that record as to who are the owners of which land. Normally, they should also, through the sub-registrar's office, they should do it. However, it is the duty of the sub-registrar to forward the conveyance copy to the city survey office or the talati and get the name changed. However,
Correct.
the government department do not take up that responsibility, and they neither transfer. Forget about they giving a document to the what is known as talati or the tahsildar or to the city survey office. Even for us, getting the original document was becoming a difficult thing. So therefore, even though we pay the stamp duty, we do the registration, getting the original document. Even today, there are many people whose documents are registered prior to 2000 are still in Pune. They are not able to get their original document. There is a question of they are sending the document to the city survey office and getting the name changed. So therefore, in order to see that our name appears in the government record, that is city survey office, it is advisable and it is necessary and it is, I would say, mandatory for the society after getting the conveyance deed, get a certified copy, make a index 2 certified copy, get a property card or a Satbara and make application to either Talati office or to the city survey office and get the name changed. So therefore it is necessary. Hemanji, in short, it is necessary. Okay.
Thank you very much.
नेक्स्ट क्वेश्चन है मिस्टर अभिजीत का। अभिजीत, आप अपने आप को अनम्यूट करें और सवाल करें। आपका जो सवाल है डायरेक्टली प्रभु सर से सवाल करें। मिस्टर अभिजीत, अनम्यूट करें अपने आप को।
Good evening, sir. My question is, can you hear me, sir?
Yeah, I can hear you.
Yeah,
Before
yeah,
you
yeah.
could say,
My question is,
wait, Abhijit, I'll just read the question.
yeah.
Sir, our builder has developed two wings on adjoining plots. One of the conditions of the IOD was to amalgamate two plots, which is pending. Builder therefore has not been able to obtain the
OC.
Yeah,
No,
completion
OC, actually,
certificate or OC.
OC.
Yeah, OC. Builder now is saying that he can convey both the plots to the society. Will this help in obtaining completion certificate post?
OC. I mean OC. Will this help in obtaining OC? I mean.
ओके, ओसी।
सर ओसी मैं बोल रहा हूँ, कंप्लीशन सर्टिफिकेट बोल रहा हूँ। ओके, so obtaining OC post conveyance. Sorry, my question is directly related to topic, but consider my question is possible. Yeah, you want to add anything, Abhijit, in this?
Actually, that is it. Basically, we haven't got the OC even after 10 years of moving in the building, and builder has been saying that basically amalgamation of two plots is remaining. That's why he's not able to get the OC, and now he wants to directly hand over the both the plots to society. So just wanted to check: is this the right way, or we have to first get the OC and then go in for conveyance, or these are two independent streams?
See, honestly, there are two independent activities. Just to give you, what is the conveyance that is going to happen? Conveyance of the land is happening, and the conveyance of the building is happening. Conveyance of the land, for that there is no need of OC. Conveyance of the building, as and where in position it can get conveyed. So therefore, to get the conveyance, you don't require a occupation certificate. OC is not required. Now the second question arises, whether I can get a deemed conveyance without the OC? Answer is yes. You can get the conveyance or the deemed conveyance without OC. So therefore, if the builder is ready to convey you the building and the land without amalgamating it and without obtaining the OC, you can still go for the conveyance. Third question is, after getting the conveyance, whether the society will be able to get the plot amalgamated and go for the OC. The answer is yes, you can still go ahead. Only thing, whatever the additional fees that may have to be paid for revalidation and approval and other things, that society may have to incur or the builder has to incur and get it done. Given the situation, more than 10 years we are not having the OC, should we go for the conveyance? My answer is yes, please go ahead with the OC conveyance, and thereafter you try for your occupation certificate. Any other question?
Thank you. Okay, thank you. I think this is very helpful. So thank you.
थैंक यू प्रभु सर। नेक्स्ट क्वेश्चन मिस्टर गोम्स का है। मैं
गोम्स का
गोम्स
सवाल है,
को
प्रभु सर,
Yes,
can a single flat owner go for conveyance if the management committee is not initiating or deliberating, dragging it for? See, as a member of the society, you have all the right to make a complaint. So what you can do is you can make a complaint to the registrar saying that under section 5, under bylaw number 5A, obtaining the conveyance is the primary responsibility of the society and it is a managing committee's duty to do it. So the managing committee is not doing its statutory duty. what they are supposed to do, and therefore you can say that the registrar may appoint a particular person. They can authorize you, the registrar may authorize you or authorize another authorized officer to conduct the general body meeting, discuss on the deemed conveyance or the conveyance, and pass the order. So this way, even a single person through the registrar's help will be able to do the conveyance. However, you will not be, as a single person, you cannot go and take the conveyance. It has to be through the general body, it has to be through the society or by an authorized officer appointed by the registrar. Okay. Next.
उसके बाद भी मिस्टर गोम्स गोम्स का ही सवाल है, इस मिस्टर गोम्स का.
Yeah.
What action can be taken against the secretary? They deliberately neglect conveyance of the society.
See, if they are deliberately neglecting, usually you can file a complaint to the registrar, you can file a complaint with the consumer court for the deficiency of service, not only against the builder, against the society. As an individual, you can go to the consumer court, file a complaint against the society, against the builder, and even builder and the society both are having a deficiency in service, not providing the conveyance, and the court, consumer court can take the action. Even you can file a case before the registrar, there is no problem.
Sir, Mr. Gomes का सवाल है, sir, since secretary refused the display records of the society, RTI was filed with deputy registrar say no record are with him at his office and unable to give is his justice as per RTI Act 2005.
See, as far as RTI is concerned, जो document registrar के पास है, that only will be able to give. Suppose he does not have the document, you can still file a first complaint and request him to call for the society and appoint some authorized person to get the documents from the society and hand over to you. So it is possible you have to file first complaint or second complaint. Whenever the second complaints are second appeals are filed with the state government has directed the deputy registrar to obtain all those documents and hand over to you or to the the person who has filed the RTI. So you will have to do this process. You have to first file an RTI. If you don't get, file the first appeal. If you don't get a good thing, then go to the second appeal. Yeah, go.
Yes, Mr. Gomes.
Okay, thank you very much, sir. Yeah, thank you very much, sir. I've already filed for first appeal, and Deputy Registrar has called me actually on 7th of this month.
Okay. So you
Thank you
can
very much.
you can there insist that
Okay, sir.
please get me. What you can say is please direct the society to produce the document to you, and from there you hand over to us.
Okay, sir. Thank you. Thank you.
Thank you. Thank you, Prabhu sir. Next question, Mr. Nemi साहब है. In Navi Mumbai with three party agreements with CIDCO has to approach to city survey department after conveyance deed. Will they also issue property card?
नहीं, देखिए, as far as CIDCO area is concerned, the entire land is in the name of CIDCO, and CIDCO does the what is known as lease in the name of societies. So therefore, or at least they maintain the record. Entire CIDCO only maintains the record. In the case of a CIDCO plot, the conveyance will be done by the joint registrar. Order will be passed, then it will be registered. Then you submit a copy to the CIDCO office, who will change the name of the holder. So maybe if Uday Shankar is able to explain this little bit better, because he is in Panvel area. Uday Shankar, are you aware of this procedures, how it happens? But certainly there is no property card system. Yeah.
Uday Shankar ji.
हाँ जी अनम्यूट कर.
Yeah, please go ahead.
Go ahead, Uday. उदय शंकर जी, आप एक मिनट, हाँ म्यूट कीजिए आप।
हाँ, सुनाई
यस
पड़ रहा है सर?
बोले। हाँ अभी
सिडको
सुनाई
इज
पड़ रहा, अभी
सिडको इज द टाउन प्लानिंग अथॉरिटी, तो लीज एग्रीमेंट जो होगा वो सिडको के साथ ही होगा वहीं पे। हेलो।
हाँ बोलिए ना सर।
हाँ, तो वही कह रहा हूँ मैं कि सिडको सिडको इज द टाउन प्लानिंग अथॉरिटी वहाँ पे। सो टाउन प्लानिंग अथॉरिटी होने की वजह से रिकॉर्ड सब उन्हीं के पास है, तो उनके फाइनल कन्वेंस जो है उन्हीं के पास होगा। तो अगर प्रॉपर्टी कार्ड शायद मेरे ख्याल से वहाँ पे नहीं है, बट 7/12 काफी है, क्योंकि 12.5% में गाउटन एक्सटेंशन स्कीम वगैरह होता है, तो 12.5% पे वो नाम नाम पे चढ़ना
ओके
सिडको लेवल पे ही होगा।
मिस्टर नेमिनाथ भोसले, यू आर हैप्पी?
जस्ट टू रिकैप्चर एंड नेमिनाथ, आपको कोई सवाल है?
नेमिनाथ जी आप अनम्यूट करें। यस सर।
Yeah, yes. So, sir, thank you, Prabhu sir and Uday Shankar ji, because we had completed our lease deed, but then I have seen the city survey department also. So I was just asking whether this department also has to be submitted this document, because the name has not been transferred by corporation on our society's name in a lot of other property tax bills and other water bills.
This is a Sidco plot, na?
Sir,
Yes,
Lemina
Sidco
ji,
drive.
Lemina ji, I would like to actually highlight there are various agencies where things can be registered. Cooperative society is being registered at joint registrar Sidco. So that is the authority. Agreements and for purchase of plot or sale of plot or for purchase of flats, वहाँ पे सब रजिस्ट्रार ऑफिस में होता है, वहाँ पे रजिस्ट्रेशन होता है. Similarly, since Sidco is also an arm of the government, and divisional joint registrar is also an arm of the government, sub registrar is also an arm of the government, प्रॉपर्टी कार्ड पे या 7/12 पे नाम चढ़ना वो सिडको के पास ही है, दैट इज ऑल्सो नाम ऑफ द गवर्नमेंट. और जब तक वहां पे नाम नहीं चढ़ेगा, एक्चुअल कन्वेंस इज नॉट डन, या रजिस्ट्रेशन, कन्वेंस डीड रजिस्ट्रेशन, लीज डीड रजिस्ट्रेशन विल बी ऑफ नो वैल्यू अगर प्रॉपर्टी कार्ड पे या 7/12 पे नाम नहीं चढ़ा तो.
Okay. Yes, sir. So, just to Neminath, just to
Yes,
further take it, 12.5% का प्लॉट है ना आपका?
नहीं, ट्राई पार्टी से 12.5 नहीं है.
ट्राइपार्टिट मतलब क्या होता है मालूम है? मैं आपको थोड़ा सा उधर का बैकग्राउंड देता हूँ. तो जब भी सिडको ने वो नई मुंबई डेवलप किया, उधर का जितने भी फार्मर्स है उनका जमीन अपने नाम से करके लिया, because it was a land acquired by Sidco. So entire property is belonging to Sidco. Thereafter, they gave certain land, whether it is 12%, 12.5% or 22%, जो भी है, they gave a part of the property to the owner. And when the part of the property is given to the owner, they made a tripartite agreement. What is the tripartite agreement? The landowner said, whatever you are given, now I am giving it to the builder for the purpose of development, and the Sidco has approved it. And once you have this tripartite agreement, that means the building is constructed. Now you are entitled to the conveyance. You have done the registration, and then you have to go to the Sidco only. Sidco will only change your name. That particular plot they will change in your name. Because all the plot details are maintained by Sidco only, as Uday Shankar ji has rightly pointed out. So there is separately, you don't have to go to the city survey office. Okay?
Okay, thank you, sir.
Yeah.
यस सर.
Thank you.
सर नेक्स्ट क्वेश्चन अनिल पाटिल साहब का है. अनिल पाटिल को इनवाइट करता हूँ. पाटिल
Yeah, owner had executed agreement with power of attorney given to the developer. Building is completed, but owner is died. Hence, power of attorney is not valid. Heirs are not interested in giving power of attorney unless they get some money, which is not possible. Builder is ready for conveyance, but power of attorney is not valid. How to convey? Sir, आपको deemed conveyance में जाना है. So what you can do is you can make the legal heirs as a party, and if they object also, still the DDR, Common Authority, will step into the shoes of the legal heirs and they will convey the land in your name. So therefore, you don't have to worry. Even if the power of attorney is expired, still they will be able to do. Dilip Megi ka sawal hai, we have got the deemed conveyance by serving proper newspaper notice. Also, property card is in the name of the society done. But landowner has filed the writ petition stating that he has not received any notice from the society in which he resides has been demolished, as it was the category. Now hearing will be on 18th December 2020 in the High Court. Sir, ठीक है, let him say all this, let it go in the High Court. High Court will listen to both of you, and then if you are able to prove that the proper service of notice was done, and even after the notice is not given, still the conveyance is required to be done. So therefore, writ petition may be disposed of. The other option, possibly High Court may remand back to the DDR, and DDR will hear him, but ultimately you will get the conveyance. There is no problem. Only thing is that there may be a little bit harassment to you. That's it. If recent document no stamp duty again, how much period means recent? What is the provision? 12th April 2012. 12th अप्रैल 2012 के बाद का जो भी चेन ऑफ डॉक्यूमेंट है उसके ऊपर स्टैम्प ड्यूटी भरना चाहिए. 12th अप्रैल 2012 का पहले का यदि लेटेस्ट एग्रीमेंट है वो काफी है. दैट मीन्स एनी डॉक्यूमेंट वेयर यू हैव परचेस्ड prior to 12th April 2012, that one document is sufficient. After 12th April 2012, whatever the new sales are happening, that you need to produce. Another case, but Anil Patil. But building is not yet complete because of the court case pending. One of the contracting structure, CC for the is held up, MCGM not removing the said structure. Hence the development is not complete. Hence can't give conveyance. How to deal with? No, if the development is not completed, normally conveyance is not given. So then you have to go to the city civil court or you have to go to the consumer court. There is no other way in which you will be able to do. Okay. So I think I have answered all the questions. Can society get deemed conveyance? Is there any other financial issue who give the loan for self-development? Right now, there are Mumbai Bank is the only institution which used to give the home loan for the purpose of reconstruction or redevelopment. But right now, that is also not possible because there is some objection taken by the RBI. So maybe it will be resolved recently, very soon. If in the redevelopment, builder stopped construction, can the allottee make a society and go for deemed conveyance? In the case of a redevelopment, that means society is already there. If the society is already there, there is no question of deemed conveyance further. And if it is a tenanted building, and if the tenants are there, they are given the ownership, then they can form the society and then they can try for the deemed conveyance. However, the construction should be completed, otherwise you don't get the deemed conveyance also.
Prabhu sir,
For deemed conveyance, how much majority is required? For deemed conveyance, it is only 51% majority is required. There is no problem. Yeah.
सर एडवोकेट रजनील सोनावने जी का सवाल है, प्राइवेटली मुझे चैट किया उन्होंने.
ठीक है, वो लेते वो लेते एक मिनट.
Yes,
in
sir,
case of a legal error, file the civil suit. Will it affect the order of the deemed conveyance? Answer is no. It will not affect. So with this, I think my question and answer is over. Yadi Sharma ji, go ahead.
Yes. Advocate Rajnil Sonavne, our is Mahada lease plot of World Bank in Charkop, Kandivali West. Are we supposed to get deemed conveyance for redevelopment?
सर माडा के लिए डीम कन्वेंस लागू नहीं है because माडा itself is a government body and you can straight away go to the MADA and MADA will be able to grant you the conveyance, and if after the application of conveyance, if they don't do it, you can file an RTI and find out the reason for not giving the conveyance, and action taken, report can be taken. You follow up with the MADA, so you will be able to do the conveyance through the MADA only. Their deemed conveyance is not possible. You will get only the lease of the land from the MADA.
Yes, sir.
With this, thank you very much.
सर हमारा एक परंपरा है कि हम जो भी कीनोट स्पीकर आते हैं उनमें से इनवाइट करते हैं पार्टिसिपेंट में से, उनको कैसा लगा. तो मैं इनवाइट कर रहा हूँ मालदार रियल्टी के मालदार, मिस्टर मालदार, प्लीज वेलकम. लाइक भाई, कैसा लगा प्रभु सर का आज का इतना महत्वपूर्ण, आप मालदार रियल्टी किस तरह से. यस
Good evening. Good evening.
Good, sir. Every your webinar is very informative, and we have been watching this webinar since 28th March till today. So it is always knowledgeable, and we have got intense knowledge as far as real estate is concerned. And really, we are very much thankful that you are still continuing with this webinar. Really, hands off you, all of you.
Thank
And
you.
even I pray to the God of Uday Shankarji's health. He is also very aggressive. Yeah. Thank you so much, Ramesh Prabhuji. Thank you so
Yes, sir.
much.
Okay. Bye. Bye.
थैंक यू मिस्टर मालदार।
Yes, sir.
तो आज के इस वेबिनार का, और फ्राइडे को निश्चित ही हम 8 बजे बात करेंगे एक महत्वपूर्ण सीए वंदन जी इनकम टैक्स से रिलेटेड विषय को बताएंगे, तो जरूर जुड़िएगा। और यस, तो प्रभु सर, मैं यही कहूंगा, जो तमाम पार्टिसिपेट कल मंडे को 118 पार्टिसिपेट जुड़े थे अजीत अर्जुन चोगले साहब की उसमें, तो तमाम लोग बड़े ही नॉलेज ले रहे हैं। और मैंने प्रभु साहब का नंबर, मेल आईडी भी शेयर किया है। आपको डीम कन्वेंस के बारे में जो कुछ जानकारी चाहिए आप अपॉइंटमेंट ले सकते हैं। नंबर, मेल आईडी दोनों शेयर किया है। और आप सभी को रिक्वेस्ट है कि ये जो प्लेटफॉर्म लगातार जारी रहे, इसके लिए आप अपने ग्रुप्स में अपने कॉन्टेक्ट लोगों को इस तरह के जो इन्विटेशन है वो लोगों से ज्यादा शेयर करें, ताकि ज्यादा तक लोगों तक पहुंच पाए। थैंक यू वेरी मच। और यूं एक खूबसूरत लाइन के साथ में इस वेबिनार के बारे में प्रभु सर, तमाम जो पार्टिसिपेट उनकी तरफ से ये लाइन है खूबसूरत, यूं आए जिंदगी में खुशी मिल गई। ये जो वेबिनार है, यूं आए जिंदगी में खुशी मिल गई, मुश्किल राहों में चलने की वजह मिल गई, मुश्किल राहों में चलने की वजह मिल गई, एक हर एक लम्हा खुशनुमा बना दिया। कोरोना काल में भी लम्हा खुशनुमा बना दिया, मेरी उम्मीद को नई मंजिल मिल गई, मेरी उम्मीद को नई मंजिल मिल गई। यस, थैंक यू वेरी मच, सभी का धन्यवाद। और आज के लिए इतना ही। आपके दोस्त और होस्ट सुनील शर्मा को दीजिए इजाजत। नमस्कार, गुड नाइट, जय हिंद, जय महाराष्ट्र। गुड नाइट प्रभु सर, थैंक यू वेरी मच प्रभु सर। और आप सभी तमाम पार्टिसिपेट, और शुक्रिया करता हूं, आप लगातार जुड़े रहिए। और आप सभी से यही कहूंगा कि सावधान रहें, सुरक्षित रहें, जहां पे भी रहें। शुभ रात्रि, गुड नाइट।